The ongoing coronavirus pandemic, the government-mandated lockdown, and the various containment measures taken by governments around the world have caused unprecedented disruptions to commercial, economic, and social activities globally, and Nigeria is not excluded. As a result of the pandemic, many people have not been able to fulfill the obligations they have made under their contracts. And in some cases, the pandemic has made the entire contract impossible to perform or even pointless. Two legal concepts may provide some relief, and they are force majeure and frustration. A force majeure event is an event which is beyond the reasonable control of either party to a contract and which makes it temporarily impossible for certain obligations under the contract to be performed. Force majeure events can be acts of God, riots and strikes, natural disasters and extreme weather conditions, outbreak of diseases, governmental actions, and more. The clause itself will need to provide that the parties will be excused for failing to perform their part of the contract if one of the events mentioned is occurring and prevents them from doing so. The event has to be specifically mentioned in order for force majeure to apply. For the COVID-19 pandemic, a clause should refer to things like government action, travel restrictions, border closure, outbreak of disease, pandemics, epidemics, etc. Force majeure gives the party an excuse for not meeting its obligations under the contract for as long as it is impossible. Once the thing preventing performance is over, the obligation continues. It could be, for example, that although the pandemic is not resolved, the fact that the party is no longer under strict lockdown means that it can now meet its obligation. In that situation, it may no longer be able to rely on force majeure. Some force majeure clauses also provide that if the event persists beyond a specified period, each party may terminate the contract. Where your contract does not contain a force majeure clause, but the COVID-19 outbreak or the government lockdown has prevented you from performing your obligations, you may be able to rely on something else, called frustration. Frustration will not be specified in a contract, but applies where the performance of the contract becomes impossible or pointless due to something that happens after the parties have entered into the contract. This event will automatically bring the contract to an end and relieves the parties of all their obligations or liabilities. An example of this may be the rental of a hall for a wedding which should have taken place during a lockdown order, or if you bought tickets for an event that was supposed to take place during the lockdown period. If money was paid before the occurrence of the event and the contract has become frustrated, such money will need to be refunded. Please note that the mere fact that the performance of a contract has become difficult or inconvenient does not mean that it has become frustrated. Nigerian courts have held that a contract is not frustrated just because it has become more difficult, more complicated, or more expensive to perform than the parties expected at the time of signing the contract. If your contractual obligations have been impacted by the COVID-19 pandemic, you should seek early legal advice regarding the options available to you and how to manage the situation.